Your Honor, my name is Baxter Barnum, acting for the accused Marshall Ike. Marshall is a 14-year-old Torres Strait Islander. Today, I will be making submissions to the court regarding admissibility of certain Crown evidence against my client, pursuant to Section 590AA of the Criminal Code. The evidence the Crown is solely relying upon in charging my client are a series of confessions that he has made. I will be making submissions to the court today that these admissions are inadmissible on several grounds. The first of these is that the police have not complied with their responsibilities under the Police Powers and Responsibilities Act. As such, the confession can be ruled inadmissible by the court as per the case of Bunning and Cross. Furthermore, I will attest to the court that my client's cultural background as an Indigenous person has caused his confession to result from a phenomenon known as gratuitous concurrence, and as such, the lead discretion may be exercised. The most salient issue regarding the conduct of the police officers comes from their breach of their responsibilities during the interrogation of my client. My client's charges of breaking and entering and stealing are indictable offences as per Section 398 of the Criminal Code, and as such, certain responsibilities apply during the interrogation process, pursuant to Section 414 of the Police Powers and Responsibilities Act. These include allowing my client to speak with a friend or relative, pursuant to Section 418, notifying legal aid due to his ethnic background, as per Section 420, speaking to a support person of my client's choosing, due to his age, as per Section 421, cautioning my client, as per Section 431, and properly recording the interview, as per subsections 435 and 436. Per the cases of Crown and Island and Bunning and Cross, provided that the police have acted in an improper or illegal way when obtaining my client's confession, the court may exercise the discretion outlined in the Christie case and adopted in Australia in the Crown and Lee to exclude this confession, provided it is in the public interest. The case of Bunning and Cross provided an objective test based on the conduct of the arresting officers to determine whether the court ought to exercise their discretion to exclude the evidence. The first element of this test is whether the police, in obtaining the confession, showed a deliberate disregard for the law. I submit, Your Honour, that on the facts it is apparent through their conduct the arresting officers did indeed demonstrate this deliberate disregard. The officers have flagrantly breached almost all of their responsibilities when interviewing my client, set out in the Police Powers and Responsibilities Act. More specifically, they have disregarded the previously mentioned sections 418, 420, 421, 435, and 436. Your Honour, I can see no reason why breaches of this magnitude would occur, other than the arresting officers having a blatant disregard for their legal obligations. Their responsibilities during Marshall's arrest include duties as simple as providing him with a caution and ability to speak to a support person of his choosing. Furthermore, Your Honour, this is a 14-year-old child. It cannot be asserted that Marshall demonstrated levels of maturity and competence to discharge police of their duty to appoint legal aid under Section 420. I would therefore assert that these breaches do amount to a deliberate disregard for the law. The second element of the test asks whether the nature of the disregard of the law in the way the evidence was collected affects the cogency, clearness, or lucidity of the evidence in question. I submit, Your Honour, that on the facts, the disregard shown by the interviewing officers clearly affects the legitimacy of my client's confession. He is a 14-year-old boy being told by police and a social worker to confess to his alleged crimes so he can go home. He has absolutely no legal aid, family, or other support network present, and no knowledge of his rights during the police interview, such as his right to silence. Furthermore, Your Honour, the interview with my client has not even been recorded by the police correctly. Can we really take the word of the arresting officers as to what was said during the interview at face value, given the disregard for both the law and my client's rights that they have already demonstrated through their actions? Your Honour, I would submit that the evidential value of my client's confession is dubious at best. The third element of the Bunning and Cross test asks how easy it would have been for the police to collect the evidence legally. Your Honour, the requirements under the Police Powers and Responsibilities Act are not onerous for the arresting officers to follow. Providing my client with his basic rights set out in the Act, such as speaking with a friend, relative, or legal aid, and informing my client of his rights, could have been undertaken with absolutely no difficulty by the arresting officers. The fourth consideration is the comparative seriousness of the offence my client committed versus the seriousness of the unlawful conduct of the arresting officers. Your Honour, I do acknowledge that my client faces 84 counts of breaking and entering along with 1 count of stealing. Although these charges themselves are very severe, the police have submitted zero evidence of any proceeds from these crimes. One would think that after breaking into 84 properties, my client would have some form of proceed to show for this. Your Honour, I therefore submit to the court that these 84 confessions that my client has provided are a result of an indigenous cultural phenomenon known as gratuitous concurrence, as recognised by the court in the Damu and Ghana case. Citizens of an Aboriginal or Torres Strait Islander background often simply agree to questions posed by an authority figure, or questions that they do not understand, in order to build respect, cooperation, and rapport with that person. I submit to the court that this was the cause of marshalled agreements to police questioning, particularly given the lack of support and legal aid that was present during the interview process. Compared to the breaches of essentially every duty the arresting officers had, I would submit that the breach of the arresting officers is far more serious than the charges that my client faces. The final consideration for the court is the intention of Parliament in limiting the ways in which evidence can be collected. Section 5 of the Police Powers and Responsibilities Act outlines this, and the arresting officers I submit have breached this intention. Part E of this section states that the intention of the Act is protecting the rights of persons. It is clear, given the nature of the breach of the police officers, the rights of my client were ignored rather than protected. As such, I would submit that the intentions of this Act have not been complied with by the arresting officers. Section 130 of the Queensland Evidence Act states that evidence may be excluded by the court if it is unfair to my client to admit this, reinforcing the common law cases of Christie and Ireland. A confession obtained in the manner that the arresting officers have demonstrated will be deeply prejudicial to the jury. I therefore request, Your Honour, based on my submissions, you exercise your ability to have my client's confession ruled inadmissible.